God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Ruddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
Thank you, Madam Clerk. Well, good morning, everyone. All right. Well, you know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? All right. Secondly, is there any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right. Again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right. And that just means I'm going to give the charge as my instructions. All right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right. So they take a while. All right. And they can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right. So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, geez. I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right. So my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all of my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now. So please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or two, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I have previously instructed you, your decision should be based solely on the evidence and the law of this case. If a defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and/or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and/or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of 3 ways. These are that the defendant A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those 3 ways. The first way of proving intent, that the defendant intended to kill is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, that the defendant A, intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right. And I discussed those elements earlier when I discussed the charge or the theory of first degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. Now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first degree or second degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora, Dawson, and or Callan Clancy. 2, that the defendant intended the conduct that caused the death of Cora, Dawson, and or Callan Clancy. And 3, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and or Callan Clancy. As I've said before, a defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right. So that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right, and I'll go over that a little bit later, but I just want to remind you that And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right. And so, counsel? All right. So we're going to return now to the instructions that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there. All right. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant for consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but and specifically for the charge in murder of the second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right. So I hope that cleared things up rather than confusing you any. Now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence, since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you, unanimously as a jury, that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless your guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason in judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial is conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider is evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'm talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions and anything that I've said during the trial, not evidence. All right, so if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence. There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when Circumstantial evidence is when no witness can testify directly about the fact that's sought to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses. All right. It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it at all. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying and whether the witness displays any bias in testifying and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts, all right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear, all right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard, all right? So I just kind of want to make that real clear. Nobody is to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that, all right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views, and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right? So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay? Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling this, I'm not suggesting you'll have one, but if you should do the following, all right? You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it, and then I'll either bring it back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process accounts for, may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop, and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing. Send me a note, and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone, all right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks, when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. Now, while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating. All right? So no subcommittees in a sense. What you do as a group. All right? You do it all together. Now I'm going to get to a difficult part, reducing and sending out the jury. All right? When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this is a lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12. All right? And so the way it's done is the clerk will draw the alternates' names. We put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so we may, and it happens fairly regularly, they would have to substitute one of the alternate jurors into the deliberating jurors. Because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. As I put in here, fate makes you an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations, and it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14.
What I kind of forgot to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count. And it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callan Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation, or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree, and there's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know that we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest, respectfully, that you each approach it with a mutual respect for the opinions of your fellow jurors. That you have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident they'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
Do each of you solemnly swear that you will take charge of this jury and keep them in some convenient place until they have agreed, that you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God? As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place separate and apart from the other members, that you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God?
I do.
Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jurors, grab your notebooks. Come to instruction. Follow vision.
Hi. Oh.
Jurors have exited the courtroom.
All right, everybody can be seated. I just wanted to make one comment. It really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing, it's intellectually challenging, it's physically exhausting. So I just wanted to commend all three counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case.